Good morning. Happy Tuesday. So, uh, people have been chiding me for getting my prediction on Lane Myers wrong. And, granted, I got it wrong. I totally did not expect Lane Myers to completely shit the bed the way he did. But here we are. So, mea culpa, my prediction was wrong. What I don't understand is that the comments from Lane Myers supporters are essentially trying to insult me for not realizing that Lane Myers would shit the bed and make his own situation worse. Now, let me explain. First of all, he filed his motion in open court. Now, I understand that Lane Myers was trying to suggest that he had some sort of agreement worked out with counsel that before this thing started that he would be able to file in court before everything else was heard, etc. However, once you're there for a specific reason, and when your case is called, it's called to be heard the thing that was set for that day. And then if you go and you say, I'm filing this motion in open court, well, then you're filing it in open court after the hearing has started on what you're there to have heard. I hope that makes sense, because there's two ways that you could file. You could file with the clerk outside of court, or you could file in court, in actual open court. And what he did is, instead of filing with the clerk, he filed in open court. Now, I understand that Lane Myers has issues and difficulties, etc. Boo fucking who? He made some choices. He is now dealing with the consequences of his choices. He went from the fuck around stage, he's in the find out stage. He fired his attorney. He didn't want an actual attorney representing him. Ergo, he has issues preparing motions and filing motions. It sucks. We understand that. That's why you have the right to an attorney to represent you, because that attorney can do things that you cannot do, especially if you're incarcerated. Now, further in the fuck around stage is that I don't think, and I could be wrong, but I don't think that his motion, even if he refiles it to be heard, if he tries to get it filed to be heard on the same date as the motion for a new judge, I don't think it's going to get heard on the same date, because the motion for a new judge is going to get heard apparently by the chief justice or the chief judge of that particular superior court. But that chief judge isn't going to make other substantive rulings in the case. He's going to send it back down to whatever judge ends up with the case, either the existing judge or a new judge, to make the substantive decisions in the case. It's supposed to be in kind of an unbroken chain of the trial judge seeing this thing all the way through to completion. I did learn something new today in the appellate documents I've read about motions for recusal. The appellate courts have stated things like it's the trial judge's absolute discretion on whether or not to grant or deny the motion for recusal. So I was under the impression that it would have been done by Metcalf, especially if it was filed in open court, i.e. during a hearing. But apparently it's going to the chief judge, so awesome. I learned a new thing about Arizona procedure. Because once again, while I am a licensed and practicing attorney, I am not licensed nor am I practicing in Arizona. But ultimately, Lane Myers is going to spend more time in court before his actual hearing on whether or not he is going to get a new bail eligibility hearing is heard. Now, I've read his brief, which sucks. It's just not, I've already looked at the cases. It's a garbage brief. The court is not required to give him a new hearing. So, it's just stupid. Like, the cases that he cites are inapposite. They don't work. I've also read the state's brief, and the state is right on most of it, except the state does make an argument that Lane does not have, that Lane can't be granted a new hearing on bail eligibility. The state essentially alleges that it's one and done. And that doesn't comport with my reading of the rule of criminal procedure, which, for those people who try to draw distinctions between the rules of criminal procedure and the Arizona revised statutes, the rules of criminal procedure are in the Arizona revised statutes. They are statutory rules. It's like 16A, 17A, somewhere in there. I forget which, but they are in the Arizona revised statutes. So it is a specific portion of the Arizona revised statutes, commonly referred to as the rules of criminal procedure. So the state does not have anything even remotely like a good argument that he is not entitled to ask for a new hearing. So once again, my prediction is, and I'm going to maybe preface it a little bit better, that once it gets in front of a judge and is actually argued and heard, and the judge makes a ruling on it on the merits of the arguments, not just saying, well, you've challenged me, so I'm going to go ahead and dismiss it. You've challenged me and you've refused to proceed with the argument on your motion. Therefore, I'm going to deny the motion without prejudice because you're not willing to argue on it at this point in time, and I'm keeping a lifeline open for you so that you can argue it again. But once the court actually makes a ruling on the merits of the motion, once again, I think that even though Lane shit the bed, even if it comes back to Metcalf, who I'm sure people are going to say, he's going to totally rule against Lane Myers because he's mad at Lane Myers. I honestly don't think he gives a shit about Lane Myers. I don't think it hurt his feelings. I don't think he took it seriously. He deals with criminals all the time. He deals with people like Lane Myers all the time. This isn't new, novel, or special for him. He's an experienced, seasoned judge. He's seen it. He's done it. He's dealt with it. He's not getting hot and bothered, but he's going to maintain decorum in his court, and that's great. So I think even if it goes back to him, he will still grant the rehearing. My prediction is still that he will grant an evidentiary hearing, and that he will limit it to the point where Lane won't get to cross-examine the victim. And at the end of it, my prediction is still that the court will find that Lane is not eligible for bail because of proof evident or presumption great that Lane violated the existing TRO and committed felonies while he was out on pretrial release. That is still my prediction, but again, I'm limiting it to when it actually gets substantively heard, assuming it gets refiled. Lane might be so obstinate that he doesn't actually refile it. But again, these are my assumptions based on when it actually gets heard. So do with that as you will. So you're right. I was wrong on my prediction because Lane Myers decided to shit the bed and essentially make it so that he stayed in jail for at least another couple of weeks. Probably, I don't know how long it's going to take to get the rehearing on the bail. To get a hearing on the bail eligibility rehearing issue, and then do the actual evidentiary hearing on that. It could be a month or more that he earned himself in pretrial custody. And once again, I don't like pretrial custody. It is not my preferred thing. All other things being equal, I think that they should be out. I think that Lane Myers could be out with a reasonable amount of bail conditions that would ensure he would not harass the victim any further. But that's my opinion. And Arizona still, if they find by proof evident or presumption great that he committed a felony while he was out on pretrial release, he's not eligible for bail, despite whether or not they could fix bail conditions that would protect the victim. So there you go. Thanks for watching. Have a great day.